Just a week ago, the Supreme Court had no hesitation in discussing videos from Samay Raina's online comedy show. The bench led by Chief Justice Surya Kant examined the controversy surrounding India's Got Latent. It came down heavily on comedian Samay Raina, saying he had taken the court for a ride and imposed a rupees 3 lakh cost on him and criticized him for violating the undertakings he had given to the court. The proceedings arose from the video clip of the show, which formed an important part of the controversy before the court. Now, fast forward to today. A petition reached the very same Supreme Court, led by very same Chief Justice Surya Kant. This time, the videos were not of a comedy show. The petitioner said they had videos showing police brutality against protesters during the July 20 march to Parliament. The lawyer sought an urgent hearing. He tried to tell the court that the video showed excessive use of force by the Delhi police. But before he could elaborate, Chief Justice Surya Kant responded and he said, I quote, "We are not interested in videos. We do not have time to watch." He then added, and I quote again, "Don't waste our time and don't waste your time," unquote. And the plea was not urgently listed. Now let's be very absolutely clear. No one is suggesting that the Supreme Court was legally bound to grant an urgent hearing. The court has complete discretion over its listing. Nor is anyone suggesting that the videos should automatically be accepted as proof. Every piece of evidence must be verified. But here is the question. Why did videos deserve the court's close attention when the issue involved a comedian's online show, but not even preliminary consideration when the allegations involved possible and visible police violence against citizens? That is the contradiction we are talking about. Because constitutional courts have repeatedly relied on video recordings in cases involving police encounters, custodial deaths, mob lynchings, and violations of fundamental rights. Videos are not judgments, but they are often the starting point of judicial scrutiny. In this case, the petitioners were not asking the court to convict anyone based on a viral clip. They were asking the court to urgently hear a plea in which videos formed part of the material they relied upon. Yet, the court's response was that it was not interested in videos. That statement has inevitably invited comparisons with Samay Raina's proceedings. The irony is difficult to miss. A comedy video receives detailed judicial attention. Videos showing citizens being beaten by police are dismissed at the threshold. Perhaps there are legal distinctions between the two cases. Perhaps there are procedural reasons that explain the difference. But courts do not operate merely through judgments. They also operate through public confidence. And public confidence depends not only on fairness, but on the appearance of fairness. When similar forms of evidence appear to receive very different responses, questions are bound to be asked. Not because people expect every petition to succeed, but it is because they expect constitutional courts to appear equally willing to hear allegations of state excess as they are to hear allegations arising from a comedy show. Justice is not judged only by the final verdict. It is also judged by what the court appears to be willing to hear.